Well, welcome. It's so nice to have you here on this. Weather could be a little bit better, but maybe if it was a little bit better, you'd be playing outside. So maybe we should be thankful for the weather. I'm Glenn Cohen. I'm a professor here at the law school. I'm the faculty director for the Petrie-Flom Center for Health Law Policy, Biotechnology, and Bioethics, AKA the longest named center you've ever heard of. I want to thank the Harvard Law School Library who helped put this together, with special thanks to June Casey, who organizes all these great book talks and so many others coming up. Also our co-sponsor, the Berkman Klein Center for Internet and Society at Harvard University. And I want to mention that immediately after this book talk, we'll go to the pub where we'll have food and libation for you, and you can hear more about health law at Harvard. So free beer, free wine, I think, free food, a great place to celebrate this event. The book we're going to talk about today is edited by myself, Professor Gasser, who you'll hear about in a moment and hear from, and also Holly Lynch, who's formerly at Petrie-Flom as its executive director, now a professor at Harvard at Penn Medical School. That was a Freudian slip, because I wish she was still at Harvard. And Effy Vayena, who's at ETH Zurich. We also received amazing support from Chrissy Hutchinson-Jones, who's in the back, who also helps run these amazing events. And my RAs, Ethan Stevenson, Brian Yost, Colin Hurd, and Wilfred Bay, who helped do the line editing. Okay. Those introductions aside, let me start with a claim I've made in a few other places that I think is really important. And that is that people talk about big data the way adolescent boys talk about sex. Everybody says they're doing it, right, to each other. Many of them are not quite sure exactly what it is. If they are doing it, they're probably not doing it very well. And certainly, they're probably not doing it in a way that both parties to the interaction enjoy, right? So what do we mean when we say big data? Typically, we refer to the 3 V's. Lots of hype here, but let's try to get down to some facts. Many possible definitions, but I think the common denominator are the 3 V's. Volume, there's a vast amount of data. Variety, there's significant heterogeneity in the type of data available. And velocity, the speed at which the data can be processed or analyzed is extremely fast. Now, some would add a 4th V, value, but in many cases I would say that's more aspirational than actual. And defined as such, healthcare has become one of the key emerging use cases for big data. For example, Fitbit and Apple's Research Kit can provide researchers with access to vast stores of biometric data on users from which to test hypotheses on nutrition, fitness, disease progression, treatment success, and the like. EHRs are quickly being analyzed, and in some instances attempts to monetize them. Countries around the world are trying to use big data to improve public health. But for all of these wonderful promises, this book, we are lawyers and ethicists after all, focuses a little bit also on the gloom, right? The real big questions raised by big data from a legal and ethical perspective. It has, I would say, at least 2 cross-cutting themes. One is the question of whether the regulation of medical record data, non-medical record health care data, and non-health care data that permits inferences about health, whether a single regulatory regime will be good for all of that, or whether we instead need multiple regulatory regimes. And that's important to emphasize because while today, and I would say HIPAA, our American system of healthcare privacy, is focused on the doctor-patient interaction, the healthcare record. And that's an extremely important source of health data, but it's far from the only source. Your social media posts, incredibly important source. Startling finding that you could actually do fairly good diagnosis of depression from Instagram filter choice, for example, revolutionized. I think a lot of people think about this. But whether it's social media, Fitbit, whether it's health records, whether it's pharmacy records, whether it's purchasing records, right? The famous story, it's true, I looked it up, it's not apocryphal, of somebody who's comes into Target. In my imagination, it's a Southern person. I don't know if they have to be a Southern person, but it makes the story sound better, right? So this gentleman comes into Target and says, I want to speak to the manager. And the manager comes forward and says, why do you want to speak to me? And he says, what business do you have sending my daughter all this information about pregnancy? She's 16 years old. The manager apologizes profusely. Well, about a month later, the man comes back to Target and says, I'm here to apologize. I say, why are you apologizing? He said, my daughter is pregnant. Turns out Target knew his daughter was pregnant before he did, right? Imagine now it's not just the Target data set, but it's everything you've purchased on Amazon, it's your electronic health records, it's your Facebook, it's your social media, it's the Nest in your home. How do we think all of these can be put together or should not be put together? What will be the effect for big data? This is the second theme on not only the healthcare professions, but medical education, society, the way we interact with each other. There are 22 chapters in this book, plus an introduction, plus an epilogue to discuss these things. They're written by leading scholars and practitioners, cover a vast terrain of knowledge, but I'm just going to mention a few of the topics covered. Is inferring knowledge about people from data the same as a privacy violation? To what extent can existing regulatory regimes be arbitraged for the world of big health data? What about Pharmacovigilance and False Claims Act? Can we use big data for that? The Americans with Disabilities Act. Will we think of discrimination, if you want to use that word, maybe that's pejorative, but determinations made on the basis of data that touch on disability or predictions about health as violations of the Americans with Disabilities Act? If not, is that a problem? How do you deal with cases where big data undersamples minority populations in terms of making predictive algorithms and the like for health? What about medical malpractice or other forms of liability in these settings? Big data and research ethics. Are there duties for us to share data and under what terms? And how do we think about the intellectual property regime, in particular patent, but also trade secrecy, as interfacing with questions of big data? It's big data, it's a big topic, but we've got some big people here to talk about it. I'm now going to introduce them. The first one who's going to speak to us is Professor Urs Gasser. These people, they have mile-long CVs, so I'm just picking a couple highlights. He is the executive director of the Berkman Klein Center and a professor of practice here at Harvard Law School. He's published more than 100 articles in professional journals, and his books include Born Digital, Interop, and a forthcoming book on the future of digital privacy. We'll then hear from Amit Sarbatwari. I always hesitate a little bit to see if I got the name. I got it exactly right? Amit is the assistant director of the program on Regulation, Therapeutics, and Law, Portal, best acronym ever, at the Brigham and Women's Hospital. He's an instructor in medicine at Harvard Medical School, an associate epidemiologist at the Brigham. He also teaches public health law at the university. He studied epidemiology at the University of Cambridge and studied law at the University of Maryland. He is a well-known scholar. You'll often catch him either on TV or testifying before legislatures or all of the above. Finally, Carmel Shahar, the executive director of the Petrie-Flom Center and a lecturer on law at Harvard Law School. She's a cum laude graduate of Harvard Law School, but also holds an MPH from the Public Health School. She teaches here, and she is really running a huge number of projects at the Petrie-Flom Center that if you stay for the free booze, I was told to mention this as much as possible, the free booze and the free food, you can hear more about what those exciting projects are. Everything from law and neuroscience on the one hand, to investment questions on the other, to even things we recently finished doing, like working on the health of NFL players. So with that kind of short introduction, I'm going to turn it over to Professor Gasser, who's going to go first.
Hello, everyone. Good afternoon. I'm delighted to be here. First of all, a little bit of a warning. I'm not an expert at all when it comes to this intersectionality, actually the previous slide, but anyway, of health law, big data, and bioethics. I'm the digital guy, right? You've heard it in the introduction. I'm working at the Berkman Klein Center. We look more broadly at the impact of digital technologies on society. And so I'm relatively new to this field, what's happening when you introduce tech to health. And therefore, my comments will be a little bit more a reflection on what have I learned as I had the pleasure to help editing this book. Before I share a few observations, I want to really say thanks to Professor Cohen and the team at Petrie-Flom for inviting us to this party. I learned a ton, and here are a few things that I've learned. So essentially what I'd like to do is share with you 6 observations, 6 takeaways that fall roughly into 3 categories. First category is understanding the phenomenon, what's going on as we introduce advanced technologies such as big data analytics, AI, the Internet of Things, you name it, to health. What is happening on the ground? Second cluster of observations is around what are the normative issues, and Professor Cohen already alluded to some of the big normative questions that arise. And then the third cluster is about okay, where do we go from here if we understand the opportunities, but as well as the challenges, and want to make sure we embrace the opportunities, but also avoid some of the pitfalls. Okay, so first observation, understanding what's happening. We've already heard it in the introduction. The big lesson learned, number one, it's complicated. A lot of things are happening. For those who are not working in health or in healthcare, the health system itself, of course, is of incredible complexity in many ways. And now you layer on top of that the technological complexity. It makes it really an exercise in managing through a complex system. And that management of complexity, I think, is a real challenge for a number of reasons. So first of all, you take the example of electronic health records and this long journey that we are in to increase interoperability among health records that then would enable us to analyze the data from many, many different sources. The reasons why we haven't achieved more interoperability are really complex, have to do with economics, fear of liability, cultures within health systems and the like. So in other words, as you introduce technology to this already complicated and complex system, it gets really hard to understand, even for experts. And one of the big lessons learned from the book and from the conversations around it is really how many different experts you need to get together in one room to better understand what is happening right now, what are the promises, and what are some of the pitfalls. So in that sense, it's a deeply interdisciplinary endeavor to talk about big data and health law and bioethics. And with that interdisciplinarity, I think a number of complications arise. The first one that I observe is one of semantic interoperability. If you're a statistician or a computer scientist who understands the AI part of whatever diagnostic system is developed, you may have a very different language and use a very different terminology from the physician who ultimately will work with this particular system, or actually the patient who will get a treatment based on what the physician or the AI system determine. So how do we deal with these different vocabularies? A simple example is computer scientists and engineers have a different notion of privacy than lawyers or many of the people in my space. And it takes a lot of time and energy to define these vocabularies, which is important if you want to understand what's actually going on, how do we label things, and what are we going to do about it. I would even take it a step further, and Professor Cohen alluded to it already. It's also that within each discipline, the vocabularies are challenged. So what is health data in this new environment, as you described it before? It's no longer clear what basic concepts mean. The same would be privacy in the legal discourse. So we have real language challenges as we even try to triangulate the phenomenon here. Last observation within that cluster is also many of the technologies that are now added make it particularly hard to understand them. Think about AI systems that reach a degree of complexity and that are really often black box technologies where even experts can't explain what the algorithm exactly was doing leading to a particular outcome. So that makes it very hard to understand, even as a descriptive matter, what is actually happening as we inject these advanced technologies to healthcare, health discourse. The second observation in this, or the second cluster of observation, as I said, is about normative issues. So the book talks a lot about these technological advancements and the promises and pitfalls. But ultimately, as you browse through it, I feel it's really more a story about big normative questions, about human questions, about societal questions, value issues. So yes, they are amplified by technology, but ultimately it boils down to big questions that we as societies, we as citizens, we as patients, we as professionals have to answer. This concerns both some sort of new challenges, normative challenges, I will get to that in a second, but also existing norm sets. Professor Cohen already mentioned it by way of example. Do we need to update certain laws and regulations that have some sort of, in the past, established an equilibrium in terms of balancing different interests of stakeholders involved? Take the example of informed consent. If informed consent doesn't really work anymore as a mechanism, or not as in past technological environments, what does that mean? Do we need to have something new, or do we need to double down on informed consent, or should we focus more on, okay, forget about consent, but we put restrictions on data, how data is used? So these are really at its core normative questions. But it's not only about like how existing norm sets are challenged by the disruptive technology and the dynamics that flow from there. It's also about some of the hard new societal questions that we're confronted with. Professor Cohen mentioned the issue, for instance, of individual privacy versus public health benefits, right? So maybe a big data set may be challenging or infringing on a person's privacy, because you could re-identify the person who appears in a big data set. But the value can get out of the data set, and the public health benefits may be enormous. So how do we think about these value trade-offs, individual privacy versus the use of technology, here big data, for the greater public good? That's not something where a technologist should or can give the answer. That's really a conversation we as a society need to have. A second example in the same category is the issue of inclusion. Turns out, and one chapter describes it in quite detail, that many of the big data sets we're talking about are not really inclusive data sets. They don't necessarily represent the entirety of a population here in the US. They don't necessarily have data in it from immigrants, let's say. Now, what does that mean if we use that data later on to develop treatment strategies, to make recommendations of all sorts, to discover some of the patterns that Glenn was mentioning? Are we, again, excluding populations that would most benefit potentially from these next generation technologies as they are applied in health? That's a big societal, it's a human question that, again, goes far beyond Internet of Things or big data. This is something that we need as a society need to sort out and figure out. The last cluster, third set, is really about design. So if we have a long list of opportunities, which are, I think, well represented in the book, as well as some of these challenges, whether it's privacy threats, whether it's fear of discriminatory practices, whether it's bias, whether it's cybersecurity threats, if you think about the Internet of Things. So it's a long list, right? So what can we do to embrace the opportunities on the one hand side, but then also manage some of the challenges as we enter this new world of AI, IoT, data analytics, and health? The big takeaway from the book is that there is no silver bullet solution, otherwise it would be a shorter book, I guess, but rather that we will need a lot of creativity and embrace essentially the full instruments available in the toolbox. Professor Cohen, of course, for obvious reasons, put emphasis on law. I will also return to that in just kind of my last observation, but it's worth highlighting that in the book there are also other tools described. So for instance, how could we work with market-based mechanisms to address some of the challenges? For instance, there is a chapter arguing we should be innovative and create some sort of clearinghouses that would address some of the problems that arise with the Internet of Things as applied in the health care sector. We should, think about standards that are competing on a marketplace, for instance, standards for privacy. So there are market-based approaches. Some chapters highlight other instruments of governance including technology. So to what extent can we deal with some of the, let's say, privacy problems by looking at privacy-enhancing technologies or new frontiers, how advanced algorithms can help to address privacy challenges. So the keyword is differential privacy here. We could go more into that. So you get a sense. It's not only about the law, but there are also other tools available. And the challenge is how can we find a mix to enable some of the good uses of the technology while addressing some of the risks and challenges. Now, the last observation is really going back to law. One of the big learnings for me from this chapter and looking at health as one big, huge case study is that health as kind of an industry or sector is not that different from other sectors we've studied before, whether it's entertainment. Remember, you know, the copyright wars 15, 20 years ago, or if you look at what's happening to transportation or any other industry, in that the reactions by the legal system and how lawyers think about disruptive technology is actually quite similar across industries. And so within health, I think you see quite clearly that there are roughly 3 response modes. One is that we try to apply the old rules we already have, whether it's HIPAA or any other norm set, and try to apply that to the new technology that enters health. And quite often that gets us quite far, but of course we also know there are limits how far that goes. And then the question arises, do we need to change the law? We heard already an example, the False Claims Act. Does that need to be upgraded? Because you can now start to manipulate data to trick, to commit fraud, healthcare fraud. So you can make gradual changes. That's another response mode that you see in many different sectors. Or you can innovate more dramatically. Maybe an example of innovating more dramatically is the GDPR in Europe, but also some of the proposals coming out in the book, including, well, maybe we have to rethink privacy more dramatically in this age of big data. Maybe we don't think of privacy anymore as an individual right, but as a group right. Because in many cases, when big data becomes relevant, it's about categorizing certain populations into groups. And that is what we may be concerned about, for instance, when it comes to discriminatory practices. So do we need to have a group privacy right as opposed to the traditional right to privacy that we think of as an individual right? So these are some of the bigger paradigm changes that are now discussed, and I think are symptomatic also for conversations in other areas. The last point, just quickly, is also going through the book, you see another recurring theme emerging about the law, which is often we think of the law as just a constraint on behavior. The law basically tells you what not to do. You're not allowed to share this data, you're not allowed to collect it, or you have all sorts of banned behavior. That's some sort of the common notion of law. But in the book, there are several instances where it becomes clear that the law can also play a leveling function or an enabling function. The leveling function, I think, is more nascent. We see a lot of discussion outside health now looking at big companies, big tech companies that have accumulated so much data that their algorithms get better and better. But what about new entrants into the market, small companies that try to compete? If they don't have access to this huge volume of data, as we heard from Professor Cohen, can they ever compete? So law, of course, through competition law and other mechanisms can address this problem. We may see some of that also unfolding in health. But certainly what we see in the chapter, in particular also the one that Professor Cohen wrote, is maybe the law in some instances in this context takes it too far in terms of locking things down instead of maybe creating an environment where we have more information flow to the benefit of health care and to the benefit of public health. And privacy is, of course, one of these areas. So Professor Cohen introduced the idea, could we flip it around and think about a duty to share information, given the benefits of information sharing in a world where any progress or much of the progress in medicine and in health will come likely from data. So really provocative thought, and I think a great example how law could not only constrain but unlock and open up some of the promises of the technology. So these are a few reflections, again, from an outsider. You will hear now much more detailed substantive analysis on some of these issues that I may have mentioned, but I hope this at least connects the discussion also a little bit to other conversations we're having, be it autonomous vehicles, AI, ethics and governance. So thank you so much. Thanks again, Glenn. Thank you.
Well, good afternoon, everyone, and I want to say thanks so much for Glenn and for Carmel for inviting me to talk about this, and in general for hosting these types of great events where I really think it is essential to bring together stakeholders from different backgrounds. And here I stand a little bit at the intersection of people who are epidemiologists who are really pushing for a lot of data sharing as much as possible, but I also stand a little bit in the world of law where the sort of risk-averse nature of lawyers comes out as well. So what I'm going to be talking about is the promise of big data. I love Glenn's analogy to sex. Everybody is doing it, and the promise of big data in post-approval research for drugs and devices, and how HIPAA and specifically high-tech constrains and allows that research, what the ethical considerations are of that, and then end with a little bit of recommendations in terms of how this can be facilitated in a responsible way. So I guess to begin, is why the increasing need for post-approval research for drugs and devices. We need to first take a look and say what we do know when a drug or device is approved. There are limits of pre-approval studies, and that entails frequent exclusion of key segments of the population, women, children, ethnic minorities. Also, the fact that these studies are conducted on short timelines with small populations, so there's the inability to detect rare but serious adverse events. An example, natalizumab and progressive multifocal leukoencephalopathy, a rare but fatal event that would have never been caught in a pre-approval clinical trial. It's only once the drug is on the market. Further, we need to stand back and say what is going on in general with drug policy. And regardless of whether or not you're in Europe or in the United States, there's increasing pressure to get drugs out into the market faster on the basis of surrogate outcomes, which we know after the fact or on occasion later shown to be poorly predictive, and increasing use of accelerated review pathways. So there is an urgent need here to be able to conduct these studies in a fast process and a robust method. And what do we have to do that? We've got a considerable amount of raw ingredients. We've got insurance claims, consumer purchases, electronic medical records. So there you see a graph just on the uptake of the usage of electronic medical records, wearable sensors, social media. So interestingly, people saying on Twitter, well, I've taken this and I have this side effect, has actually been mined as a way the FDA has explored those opportunities to say, can we catch early adverse events through that system? And increasingly biological registries. So there you just see the decreasing cost of whole genome sequencing, eventually getting to a point where everybody can have this done if they want it. So this is a beautiful slide by Isaac Cohen in JAMA, and I'm not going to unfortunately be able to do it to justice, but here you can sort of see the types of data that exist, the structured and unstructured nature of it, and how all of these pieces sort of fit together. But really the key of this is these are all isolated pieces of data. Their magic is putting them together. And the question is, what are the systems in law that allow us to do this or that hinder that? And whether or not that balance from an ethical perspective is appropriate. So what, in terms of data sharing to aid post-approval research here, what do we have? In terms of the facilitation of observational study, what does this data sharing do? It enables enhanced capture. So let's just go through a couple examples here. So people with relevant exposures and outcomes, we know in the United States there's considerable churn in health insurance. So I might have access to certain people who start a medication in one claim database, but if I can't follow them through over time, I don't know if they actually suffer an adverse event. So the only way I'd be able to do that is by linking those claims databases together. In terms of variables of interest, my claims data isn't ever going to have information on things like BMI or smoking, because that doesn't affect whether or not I get reimbursed by the insurer for that. But the EHR, the electronic health record, might have that information. So if I'm able to link those together, now I have more variables to study. So again, one problem with claims data is that if I'm looking just at claims data, once people go into the hospital, it becomes a black box. And so I'd like to be able to know what happens inside the hospital, but also outside of the hospital. How does that happen? By sharing this information together. So by enabling this data sharing, I'll be able to have improved statistical power, more rigorous adjustment for confounding, and more detailed subgroup analyses. That is particularly relevant in the context of precision medicine. So now I need robust statistical power to be able to say which people are particularly benefiting from this treatment and which people are more prone to suffer adverse events. And in this era, with the amount of data that's out there, there's the ability to do this. But the question is, how does HIPAA sort of constrain this or enable it? And one thing I want to say is, I think HIPAA gets a little bit of a bad rap in the sense that I think there is considerable flexibility built into HIPAA. Now, it remains an open question whether or not that flexibility is sufficient or is it proper in the realm that it covers, because again, as Glenn alluded to, we're only talking about a certain stream of information that it's covering. So here, it's a little bit of a background here. The security rule covers electronic protected health information maintenance and transmission, and the privacy rule covers conditions for the disclosure of PHI. And patient authorization is not required, among other things, for treatment, payment, and healthcare operations, for public health activities, and what we're talking about here, for research. So you can get an IRB waiver if there's not more than minimal risk. But in the context of observational data, observational studies where you can say the risk to the participant is probably minimal, and we can debate that. The problem with this process is there have been reviews that have sort of shown that we're worried about inconsistent or ambiguous interpretation of federal regulations. We're worried about changes required by certain RRBs and not by others, and what that does to the overall research protocol. So with that in mind, what does HIPAA enable in this context in terms of data sharing independent of IRB authorization? So it permits covered entities and their business associates to disclose PHI without patient authorization or IRB waiver of authorization through two paths. One is two general paths, and one is a limited data set, which removes 16 specific identifiers, and I'll come back to this in just a second. The other path is de-identification, and de-identification involves turning PHI into non-PHI, and there's two paths within that. One is a safe harbor mechanism, again, is just saying as long as you don't share 18 identifiers, you're fine. The other one is a bit more ambiguous. It says expert determination. So I can share any data as long as an expert says that the risk is very small that the information could be used alone or in combination with other reasonably available information to identify an individual. What does that mean? We'll get to that in just a second. So now, what about those cookie cutter pathways, the 16 identifiers or the 18 identifiers? Is this going to allow us to do the research we want to do? Let's back up even further just a second and say, well, why don't we just get patient authorization? We've talked about why IRB authorization might be problematic. Why not patient authorization? Here we're talking about millions and millions of patients, and the process of doing that would also be constraining. So assuming that this is a pathway we want to explore, we find public health value for using, this safe harbor says these are all the identifiers you cannot share. And as long as you don't share this information, what you're sharing is de-identified information. So in the context of post-approval drug research and surveillance, there's some things that sort of are flagged as potentially problematic. A key element in any good observational research is an element of date, right? We need to have some sort of timing here as far as when a drug was taken and when an adverse event happened. Device identifiers, if we're doing drug and device research. Also, addresses, because addresses are oftentimes the only piece of information which we have to understand socioeconomic status, which could be an important confounder in the type of research we want to do. So that being said, well, there are some pathway problems with just these limited data sets or the safe harbor pathways. The limited data set, there is this issue of what I am converting. It's only 16 of those identifiers can't be shared, and I can share elements of dates, but under that pathway, it remains PHI, and thus there is still liability associated with the disclosing party. And then with the safe harbor pathway, we could perhaps, here's the hidden flexibility. Now, if you're a lawyer and you say that, it says, what can I not share? All elements of dates. Well, maybe I don't need to share an element of a date. Maybe I just needed to share time to event information. So maybe I just say that from an arbitrary reference point, somebody took a drug 50 days later and then suffered a myocardial infarction 75 days after that. Well, could be sufficient. Could that perhaps get us out of this conundrum? Think about what I said about the need to conduct these studies faster and in as much as real time as possible. As those studies become quicker and quicker in duration, we are implicitly going to violate that rule about sharing elements of date. And here's just one example. So this is an example of a study that was conducted in Italy. And we can assume if, let's say it was conducted in the United States, and somebody this involved a vaccination and whether or not there was an adverse event associated with the vaccination. This study was conducted from October 2009 to January 2010, inclusive. And so now I say, well, what happens if I actually say that from 200 days arbitrarily after some arbitrary reference point, the person had a vaccine, and then 40 days after that, they had an adverse event? By just knowing when this study took place, I would know that that person could not have been vaccinated in 2010. It had to be in the second half of 2009. As a result, have I shared more than an element of a date, more specific or more granular than a year? I have. So again, showing you there's flexibility, but that flexibility still hits a little bit of a roadblock in terms of how much information I can share. So there is this expert determination pathway. And that expert determination pathway says, well, maybe anything goes. Maybe I can craft this specifically in terms of what information I want to share. I just have to have an expert say that there is a low risk of re-identification here. Now the problem is, well, really, what does a low risk of identification mean? Who is an expert? And are there certification standards around? The answer to all of those are these are still developing questions. And because these are developing questions, and because there is potentially a risk of liability for certifying something that is actually unsafe, there is the problematic sort of nature that this pathway it exists, but is not being used in a way that would be conducive to the data sharing that HIPAA actually permits. So to back up 1 second and again say, well, what are the ethical considerations at play? And we've heard this. There is this inherent tension here between wanting to put forward as much data sharing as possible because that will be beneficial from a public health standpoint. How much time? Oh, great, thank you. Because that will be beneficial from a public health standpoint, and that tension between saying we want to value people's privacy and their right to make determinations about their data that theoretically they should own or at least have some say in how that data is used. So here is where epidemiologists, computer scientists come to the situation with a little bit of a different perspective than lawyers. A canonical piece now in privacy law is The Myth of De-Identification. I don't know if you guys have read it, but if you haven't, you definitely should. It's by Paul Ohm. But he cites a couple of examples, most notably one that I particularly enjoy is by a professor here who, as a graduate student, LaTanya Sweeney, sort of proved that the information that Governor Weld at the time wanted to release into the public domain was actually not de-identified. So this related to hospitalization records of state employees. And what she did is she basically combined that data with census data, and she showed that she actually identified from that de-identified database which records were the governor's and mailed them to him. So these examples are shown in the law literature as the myth of de-identification. But when you talk to computer scientists who do data privacy, they'll say, look, first of all, that's not a case of HIPAA de-identified data. And if you actually take a look and try to model attack scenarios about how you can re-identify what is HIPAA de-identified data under the safe harbor, it is very, very difficult. Even if you can identify a small subset of individuals, then the question ethically is, what risk are we willing to accept as a society as okay in terms of being able to facilitate this data sharing? The real question is not, is there a case of no risk? There's never really a case of no risk. And what we need to have more public discussion of is, what is an acceptable level of risk? And so this slide just shows examples of how difficult re-identifying HIPAA de-identified information actually is. So here, I just want to say, with that in context, what we put forward is a couple of recommendations in terms of how you can potentially start the ball rolling in developing these certification standards. And we just come up with a few general principles, which is that in terms of the risk threshold setting, if we are saying what an expert should be involved in, first, we should say that not all risks are created equal. And so even though the expert has a considerable degree of discretion given regulations, given guidance on what an acceptable level of risk is or what a very small level of risk is, the expert should select a risk threshold proportional to the potential harm of the re-identification. Not all re-identifications are the same. If I re-identify someone who's taking a statin versus re-identifying someone who is taking pre-exposure prophylaxis for HIV and AIDS, the potential danger I could cause to that person is different in each context. So let's consider that as one. Two, let's model different types of attack scenarios. We don't really know who the attacker is going to be. It could be a prosecutor. It could be somebody who's looking for a specific known person. It could be someone who's trying to identify any person in the database. Or it could be a marketer, someone who's trying to re-identify as many records as possible. When we are trying to say what the risk is, we need to explore all of these different options. And then in terms of risk mitigation, we shouldn't be overly conservative in terms of the level of risk that we're willing to assume. And finally, in terms of the experts, there are other ways we can go about doing this in terms of furthering the likelihood that there won't be risk. And one of those is, why don't we routinely use data sharing agreements that conditions the way in which the recipient party will use that information? So hopefully this gives you a little bit of a subset of some of the samplings in the book, but thanks.
All right, hello everybody. My name is Carmel Shachar, and as Glenn mentioned, I'm the executive director of the Petrie-Flom Center. So before I start talking on the substance, a few completely shameless plugs. First of all, working on this chapter and then joining the Petrie-Flom Center was not my first encounter with the center. I was a student fellow here And for all of the students sitting in the audience kind of checking us out, I would highly recommend that you go that route, because who knows, maybe one day you might steal my job for me. The second thing is, if you are perhaps a little bit past the age of students, and I certainly don't see anybody here who appears to be a day over 23, but there are many ways for you to get involved in the center that are different than being a student fellow. I would highly recommend that you sign up for our newsletter. It comes out only every other Friday. We strongly believe in not spamming. It'll let you know when all of these great events happen. So if you enjoyed this, there are many more events to come. I believe that we have some information in the back that you can take if you're curious, or please feel free to talk to me. All right, now that I've finished the shameless plug of my section, let's talk about the chapter that I contributed to the Big Data book. My chapter really looked at a fairly recent Supreme Court case, Gobier versus Liberty Mutual Insurance Company, to look at what happens when law impacts the collection of big data, because that's really step one. You can't do all of these cool things that you claim to do with big data if you can't collect it in the first place. And here I'm going to walk you through, and this is going to be short, 20 minutes, because I stand between you and the questions, and more importantly, the free alcohol. I understand. I'm going to introduce you to two concepts that are not particularly sexy, all-payer claims databases, as well as ERISA, and explain to you how their intersection led to actually a very interesting case that had even more interesting public policy ramifications on how we try to get information about our healthcare system and build a better healthcare system for everybody. And then I'm going to talk to you about potential solutions. So first, I said all-payer claims database, or APCDs. I mentioned ERISA. What are these two concepts? So the case I'm talking about was based on the Vermont all-payer claims database, and that is actually a great sample for us to use. All-payer claims databases contain medical claims, pharmacy claims, dental claims, as well as additional information about patient and provider demographics in an area. And it includes public payer information, which is relatively easy for us to get, your Medicare, your Medicaids, but it also includes private payers. In most states, until recently, when they wanted to aggregate this information so they could really get a sense of all the claims happening in a state, required all employer-sponsored health insurance, that's the type of insurance I'm willing to bet most of you guys have, to enter their claims information into their APCD. One thing to note is that the end user of APCDs is usually not the patient. So you're not going to the Vermont APCD database to look up and remind yourself, wait, when did I get that prescription for antibiotics, or when did I have that burn that I got treated? The end users are policymakers, are researchers, are people who are really trying to understand what is going on with our healthcare system. This is a tool that, especially in a fragmented system like ours, is really invaluable for getting these overarching data sets. I also mentioned ERISA, and when I gave this presentation at our annual conference a couple years ago, I used the joke that ERISA is so boring, even lawyers find it boring. I have not learned anything to disprove the truth of that joke since then. So I will do this very quickly. ERISA came of age in the 1970s, and it's meant to regulate employee benefit plans that employers sponsor. The idea is that these plans should be consistent across the country, they shouldn't be overburdened by states, and there should be some accountability so that employees know what kind of benefit plans they have. One of the most important and interesting concepts there is the concept of preemption, saying that the federal government's laws trump the state laws. ERISA has one of the broadest preemption clauses of any modern federal statute, which means that there have been a whole host of cases trying to figure out at what point does ERISA stop and state law begins. I often liken ERISA to the fat woman singing. When she sings, everything's over. Before Gobier, the case I'm going to talk about, The standard was that a state law was preempted if it had a connection with or to reference to such an employee benefit plan, which was still fairly broad, but had this idea of a strong connection. You're really touching something that ERISA should be regulating. One thing to note is that ERISA does have a reporting requirement, but its reporting requirement is really limited to the financial health of the employee benefit plans, including health insurance plans, rather than the APCD's reporting requirements, which is looking at healthcare data explicitly. So now that I've gone through those two concepts, let's talk about the Supreme Court case that inspired me to write this chapter. The central issue in this case is whether ERISA preempts the Vermont state law requiring all health insurers, including those who are self-funded by employers, to report claims and healthcare service data to the state in order to flesh out the data set for the APCD. Specifically, the question was whether ERISA preempted the Vermont statute in establishing a unified healthcare database and requiring health insurers to report healthcare claims data that may not necessarily be financial reporting data. Again, I emphasize ERISA wants you to report financial data to look at overall, is this plan healthy? Is it going to be around to provide the benefits employees were promised? Whereas the APCD could, in some ways, care less if your health insurance plan was around tomorrow. It just wants to know what your health insurance plan has already paid for. So the Supreme Court concluded that ERISA did indeed preempt Vermont's APCD. It said the Vermont law had a connection with the ERISA plan, that it tried to govern a central matter of plan administration, in this case, reporting, disclosure, and record keeping, and that it interfered with ERISA's goal of having a national uniform plan administration. One thing I want to highlight, and we're going to talk about it under potential solutions, is that Justice Breyer wrote a concurrence in which he noted that this decision would cause serious administrative problems. So he said this is good law, but perhaps not good public policy. And he suggested that the states work with the Department of Labor, which is the agency charged with issuing regulations around ERISA, as well as the Department of Health and Human Services, to remedy this issue. Justice Ginsburg wrote the dissent saying that Vermont's law should not be preempted by ERISA, and that was because she felt the record collection were so different that having the APCD and requiring to report this information in did not impose a substantial burden on ERISA because they elicited different information and served distinct purposes. So now I've introduced you to APCDs and ERISA and explained the collision between the two. But you might be asking, okay, why is this a concern? Why should I care about this? How does this relate to big data? Let's go back to the sexy metaphor about teenage boys. Well, first, let's talk about the overall impact. This is a map of what APCD land looked like in 2016, right before the case came out. We had about 18 states with APCDs, about 12 interested in developing them. And a lot of the reason that the states wanted to do this work is because everybody's talking about the runaway cost of healthcare, right? You read a million articles on that. And states felt if we have an APCD, we can know what is being spent. And that transparency is the first step to controlling costs. Now, in 2018, the map looks a lot grayer. And the gray are for states that have decided, I'm not really interested in doing anything with APCDs. So already you have a lot of states that were going to try to do these big uniform data sets that would have been really interesting to play around with and walked it back. I also want to say this map is a little misleading, I think, because the blue states are states that have APCDs, but after this Supreme Court case, they don't have the complete data. They're so far from being a universal data set. So to give you a sense of it, in 2017, about 151 million people had employer-sponsored insurance, of which 60% were self-funded by their employer. So these are the plans that ERISA protects and that after Gobier, we couldn't collect data on. In Vermont alone, we know that the ruling eliminated about 20% of the total population from the data set. That's a really big chunk. Furthermore, the people eliminated, it's not consistent. So in Vermont, we know that a higher percentage of non-elderly women, 59%, as compared to non-elderly men, 55%, are covered in these employer-sponsored plans. So we're losing more women, and our data set is getting less representative. And the less representative our data set is, the worse the conclusions that we can draw from it is. So we also have a problem when we have data sets now that are composed largely of public payer data, because Medicaid and Medicare do cover a ton of people. You can get some really interesting data out of that population alone, but Medicare obviously skews very old, and Medicaid skews towards lower socioeconomic status, and so that's very different healthcare data than when you include the employer-sponsored people. So here I'm going to give you the pitch on why APCDs were really useful and exciting. Here were some of the types of things that states were trying to do before this Supreme Court case. So Colorado was trying to use its APCD for price transparency, to try to increase competition for maternity services and hip and knee replacement, to improve those prices and bring those costs down. In New England, a researcher used an APCD to compare outcomes of services for children enrolled in Medicaid and children in commercially insured plans, which now you can't necessarily do because you're missing that chunk. And they found that there were serious problems and differences in outcomes between these two populations, which might be common sense, but also is very important to study. Lastly, the opioid epidemic is obviously a big issue in our country, was in 2016, unfortunately continues in 2018. And in Maine, people were using data from APCDs to try to see what sort of patterns could indicate that somebody either had a substance abuse issue or was at risk of developing it, so that they could flag those people for earlier and earlier interventions. These are all worthy topics. Some other issues I want to raise when you try to do big data work with APCDs when they're incomplete data sets is that you lose the ability to catch a lot of things. So Amit actually mentioned this drug earlier, but in a large enough data set, you can see these really rare but important side effects that can't be caught as you reduce the number of data points you have in your data set. So just from a sheer numbers point, we're losing something. There's also the issue of the validity of the data. After all of these employers say, no, I want to keep my information proprietary, especially when you're trying to do research on the impact of socioeconomic status on health and health outcomes. Lastly, we're losing a key resource for gauging health status and needs. So, for example, researchers in Tennessee tried to see what the outcome of using a particular antibiotic would be. And they found that there were some serious health outcomes, enough to say you should not be using this antibiotic to treat this condition. Danish researchers tried to recreate this study using their equivalent of an APCD, and because of their healthcare structure, it truly was universal across all economic classes, and they didn't find this outcome. And they theorized it was because the Tennessee researchers had used Medicaid data only. Because of the confluence of socioeconomic status and health outcomes, they were only seeing the more vulnerable as opposed to the general population. So hopefully at this point I've convinced you guys that having incomplete data sets is actually a big problem for everybody and not just for the kind of people who like to write chapters in books titled Big Data in Healthcare. Here I want to suggest a couple potential solutions. And now I referenced giving this talk in 2016 at the Big Data Conference. And when I went back to my slides to update it in 2018, I found that I needed to do virtually no updating of potential solutions because nothing really had happened. And I think this is, again, the issue of sometimes an important development happens in the law, but for whatever reason, the public policy community isn't as invested in it, and so not much happens. So the biggest potential solution, and the one that Justice Breyer noted, was he said, the Department of Labor is responsible for ERISA. They should issue regulations requiring the collection of this data. This did not happen. The Department of Labor essentially did what I do when a friend that I don't really like texts me to ask if I want to go out to dinner. They kind of said yes and let it die. So the Department of Labor in 2016 issued proposed regulations to collect this data. And there were problems with those regulations. The data they wanted was not as complete as the states were collecting. They said, let's collect it on an annual basis as opposed to a monthly basis. And a lot of people wrote in. There were about 300 comments, which is pretty good for something that is a little bit on the drier side. And then they did absolutely nothing with it. They still have done nothing with it. It is not on their list of priorities. And I think they rightly say, we don't really know healthcare. We don't want to get in the business of collecting healthcare data, and there just isn't the political appetite to do it. There are also some other issues, whether if the Department of Labor tries to collect this data, are they able to waive preemption and say, states, just collect it as you want? Would that open them up to another round of follow-up litigation? The issue of if they collect the types of data that fall under their purview, which is just the self-employed plan, okay, then they have an incomplete data set and the states have an incomplete data set. And can we necessarily hook them up to create one whole one that is going to be as good as if one entity had collected that data in the first place? And then again, there's just the political appetite for it. It's not their priority. Of course, private industry has tried to step in here, and some healthcare data are volunteering their data. So Aetna, Humana, United Healthcare have put together a database that some researchers have used, but Blue Cross Blue Shield, which is a major insurer, has not volunteered their data. There's also the issue when you volunteer what you want, and it might not necessarily be what's needed. There's a group called the APCD Council, which is trying to spearhead a common layout to say all states should use this layout in order to collect data, to make it more uniform, to ease the administrative burden, and that's a step in the right direction. But without regulations or real big push for people to adopt that data sharing, that template remains just a template. So I want to highlight that saying voluntary contributions are the solution kind of stops before you tweak it to make voluntary contributions appealing enough to do on a widespread basis. Some things that we need to think about are tax incentives to get health insurers to do this, incentives to third-party administrators who administer these plans, again, to say we really should be sharing our data, offering incentives to employers. But then we also need to talk about what sort of changes to data privacy regulations and liability regulations do we need to have to allow these entities to disclose information that might otherwise be tied up in fears of violating HIPAA or be tied up in non-disclosure agreements. And so I wish I could end on a slide that said things we have accomplished since 2016 to make sure that we have good quality healthcare data. We haven't. On the other hand, that leaves an opportunity to really improve this and make sure that we continue to have the kind of big data sets that we need in order to do some of the interesting work described in our book.
Hopefully you got something interesting out of the exchange. If you want to share what you got out of that exchange, that'll be great too. But we have the first question, I think, over here.
Adrian Grapper, Patient Privacy Rights. I feel to some extent that I'm listening to a bunch of astronomers before Copernicus, sort of wondering why do the planets move, these things in the sky move the way they do. And in the sense that both the law and everything around that we're talking about here is focused on institutions being where all the data processing, all the information technology rests, and the individuals do not. People do not, the patients, the people do not have agency, do not control technology, do not have ways of automating the authorization for how data is used for all these wonderful purposes. And that to me seems like it's rapidly obsolete as a concept, because as Facebook and everybody else aggregates these data sets, in various ways, we realize how valuable they are. Roche paid $2,000 per patient for cancer data on 1 million patients earlier this year. And yet Moore's law is driving the technology down to where, compared to $2,000, controlling this data yourself is trivial. How do we get to this next phase of technology and law?
Who wants to take the first stab?
So I will say, I think Facebook is a really good example, not only of the dangers of what happens when we think that companies and entities own people's data as opposed to people themselves, but also in terms of the market forces, right? We all know Facebook has some really terrible privacy practices, but how many of you are pulling your Facebook and Instagram profiles and joining some social network that advertises itself as having better privacy practices? I think I've seen studies indicating that people say they value it, but they have yet to act on it. And I think some of that next stage of the data revolution you talk about will really only happen when people start saying, I will only see providers that give me control and ownership of the data, or I will only use apps that explicitly give me ownership of the data.
And I think you raise a great point in the sense that I was focusing in on a discrete situation of research, but we're talking about, when we're talking about HIPAA, we're talking about a constrained area in terms of a universe in which a lot of commercial data sharing is taking place and a lot of, frankly, exploitation is taking place. And there are definitely solutions that can happen there. And I think one framework that Urs mentioned that is helpful to think about is how do we operate within the existing law, but how do we also now learn from the European experience in terms of this wider realm of data privacy and agency that we are going to give individuals in terms of how their information is used.
Okay, we've got a question over here, and I got to say, before you ask your question, I'm sure it's going to be excellent, but that outfit is outstanding. Okay, go ahead.
Thank you. I have a question for Amit. You showed a very interesting slide where there were several streams of data, medical records, wearables, claims, all of that. One of the things that I was actually wondering about that slide is like, where is like medical error data? In the US, medical error is the third cause of patient death. In 1999, the National Academy of Sciences published a report noting that around 98,000 people die in the US because of medical error. And 2 years ago, researchers from Johns Hopkins University School of Medicine actually updated the report and showing that the actual count is higher. So it's not 98,000, but actually between 250,000 and 400,000 deaths because of medical error. So I mean, those numbers are very big, and they really remind us about how inefficient healthcare in the US is, and also how patient death due to medical error is an under-recognized epidemic. So how do we integrate that within that slide?
So again, excellent question. I think that one of the things to recognize about that 98 or whatever, that Institute of Medicine report, and then this more recent Hopkins study, it took a lot of heat among the medical community because a lot of that is based on extrapolations from very small samples. And the problem of medical error is huge. We don't honestly know specifically how huge it is, and one of the problems is the ability to study that question systematically using representative data is part of the problem, is access to a single streams of information. So some of that information could come from EHR data, but you need to have EHR data from hospitals that are academic medical centers that have great EHR systems, plus rural medical centers that don't. And how do you start doing this in the process of, as we're getting into a more digital age, we need to be able to combine those data streams in an effective process. And part of the barrier is not necessarily what HIPAA says, but the way that people interpret HIPAA and the risk-averse nature that a lot of people have. So I think it's an important recognition that medical error is one of those types of things that could benefit greatly from greater data sharing.
Maybe I'll just add a point on this. So one good error you did not make, but sometimes people do make, is conflating medical error with medical malpractice. In that, the best studies we have, my old colleagues Michelle Mello and Dave Studdard, show that actually the medical malpractice system does a terrible job in both directions. It claims things are medical error that are not medical error, and it misses many things that are medical error by labeling them no recourse available. And the other thing I'll say maybe is that even if you could do this well and measure it through the big data, there'd be a question about what you do with that data. People who think that patients care about that data, I got to say, the results from what we see about care quality and attempts to communicate this with report cards in states like New York and Pennsylvania are very upsetting if you're like, data wants to be free, empower the patient, ... Turns out patients tend to still prefer word of mouth over data when presented it. Now, maybe that's a fault of ours in the way we've presented the data in the past, but I would not rely on patients to be the engine for change here. If anything, it's likely to be accreditors, hospitals, insurers, and the like.
And just one follow-up point to that is one of the V's that we don't mention in terms of what big data is veracity, and a lot of big data, frankly, is crap, and so we need to be conscious of that.
Please.
So Professor Cohen touched a little bit on sort of undersampling of minorities in data sets, and I guess something related to that is that a lot of the time when machine learning algorithms are making predictions based on data sets, it's a black box, so it's unclear what it's doing and how, and I'm sort of interested in how the law is sort of going to react to that element of AI.
Maybe I'll start, because we do have a project on precision medicine AI in the law, 5-year project that's exactly about black box medicine. Here are a couple of things that I think are interesting about it, but I think it's quite complicated. One is actually on the intellectual property side, about the trade-offs between trade secrecy on the one hand and patent on the other, and difficulties because of both the European and the US jurisprudence about patent that prevents people from patenting many of these algorithms and therefore pushes them towards trade secrecy regimes, which are much less transparent. So that's one issue. The other, I think, more interesting question has to do, maybe two more, and then I'll turn over to someone else. Second one is about medical education and the conception of the doctor's own role. I'm not a physician. I have at least one physician on the dais. But in a future where many of the decisions and advice you're giving are things that you can't explain in human language because it's non-interpretable machine learning, one wonders how one trains a generation of physicians that will interact with these systems. And the last thing I'll say is just about liability. Very large amounts of uncertainty about what happens when there's an error. Does the device maker that has one of these systems built into it have the liability? Does the hospital system have it for adopting it without doing its due diligence? Does the physician have it? What we know about the jurisprudence on computer decision aids, which is probably the best analogy, is that physicians are basically held to the standard of care they normally are and have responsibility for this, even when it comes to a system that they're pushed to use, even when it comes to a system they don't understand, even when it comes to a system that's built in their workflow that it's quite difficult for them to override. So if you're a physician, I would say this is one of the things that maybe should concern you about black box algorithms.
Just one thought I wanted to add. I mean, I really believe this question of inclusion is one of the very big challenges in health, but also more generally as we talk about AI and the power of data and algorithms going forward. And specifically here, as you mentioned in your presentations as well, that I do believe this is really an ecosystem level challenge. Some of the promise we've heard is that we have Fitbits and we have all these alternative sources that may give data points that then can later be analyzed. But if you look at it, who has access to this technology? Who's actually affording to wear Fitbits, and who has access also in terms of institutions, hospitals, your example you just made? We still have real digital divides and participation gaps. And so I do feel there is a deeper challenge not only looking at the big data side and how to create inclusive data sets, but even more so who has access to the basic technology and under what conditions. And then lastly, there is also a challenge in who is designing these systems. It's a debate that we are very much interested in more generally. Is it Silicon Valley designing now health applications, and what are the design bias by our friends at the West Coast, right? Is that a representative group of designers that thinks about underrepresented communities, for instance? So I really believe to focus on data and data sets is hugely important, and there is also much progress made to make more inclusive data sets, but that alone will not do the trick. This is really ecosystem level problem from my perspective, at least.
So I will jump in to say that 1557 of the Affordable Care Act, Section 1557, was designed to try to bring anti-discrimination law specifically to the healthcare context. It was the first time it was explicitly applied there. And now I think 1557 has some interesting potential to reshape the way that we distribute healthcare. I think it will probably take a change of administration and or Congress and or several changes of administration before somebody dusts it off. It is still technically on the books and does something really creative with it. Having looked at trying to bring discrimination claims in the context of insurers' benefit design, it's really, really difficult. But there is a kernel of an argument there, just nobody has really been able to effectively pull it out. And I think at a certain point, you could try to pull it out in the context of if you're developing algorithms that make medical decisions, and these algorithms are based on data sets that we know to be problematic from a race standpoint, then continuing forward with that product may look discriminatory. But I would say that's many law review articles, many court cases, many clinic students away from being a fully developed legal theory.
So let me ask a question to you, the panel, and this is kind of a general kind of question. If you look back at this conversation 10 years ago, I doubt you'll remember that we sat here 10 years from now, but let's just say you did. What do you think your big Homer Simpson doh moment is going to be? What is it that you're going to think you got totally wrong about how the future is going to develop? Or what do you fear you might get wrong in terms of the way you've been thinking about this up until now, that you think the future might be radically different than you think it's going to be?
So I will go first, and I will kind of sidestep the question a little bit to say...
You can tell she went to law school. Yeah. Avoiding the hypothetical.
Yes,
go ahead.
Exactly. I was taught by the best. I will say about 10 years ago, I started law school, and I knew one person who had an iPhone. And that was a big deal. That was my defining characteristic. Oh, that's the girl with the iPhone. And I had no idea that in 10 years, we were all going to carry around these pocket computers, and I was going to tell it every little detail of my life, like an app. And when you look at HIPAA, I think some of the challenge of applying to HIPAA was written in 1996, way before there was even one girl with an iPhone. There were no one with an iPhone, and nobody could really think about data in the sense of this personal access point. They thought about it in terms of computers and offices. And so I think probably in 10 years from now, we are going to look back and be like, remember when everybody carried around phones and you didn't just speak to the air or blink your eye twice and that sent data to something? So I think it's going to be a completely different paradigm.
I guess one thing I'm a little bit worried about is if we don't act to regulate the outside of HIPAA space in terms of data privacy, and we don't give more rights to individuals, that all of the potential promise of data sharing, that we may enter an atmosphere and a society that is very rigid in the way that it now wants to share data, and that if we don't get ahead of the curve, that we are not going to enter a world of the promise of big data, but rather the loss of potential that was once there.
I think I have two answers, and the answers contradict each other. On the one hand side, I worry that somehow we are on a path, in a path dependency mode, where we are not really embracing the opportunity that is ahead to build better systems, to build better healthcare systems for more people, because of a lack of imagination, because of a lack of, due to the constraints that are within these institutions that came up before. So that's one worry. And then I have the other worry, which is almost the opposite, that the transformation we're going through will be so dramatic and so radical that we're vastly underestimated how transformative it will be, and that the biggest challenge will go back to your point again. How do we preserve human autonomy and human agency as things become more institutional, more machine-driven, more machine-decided, and what does that to us as human beings, and where are the safeguards for that? So this is a contradiction, but two things I worry about.
So Yogi Berra said it's very hard to make predictions, especially about the future. But I will say that it's much easier to have confidence in your predictions when you have free beer in your system or free wine. So I'm told we should wrap it up so that we can enjoy downstairs. But please join me in thanking this amazing panel.